DUI is big business and big votes, and wherever there's money and votes, you'll find laws making it easier to put them in the pockets of people most likely to benefit. It's a political issue, and one that politicians can safely get behind, especially when forces like MAD are brought to bear. Here are my 7 predictions for the future of DUI prosecutions. Cops will target drivers impaired by marijuana. You can buy pot over the counter in Colorado. Washington and Oregon have decriminalized simple possession. More than 20 states have laws legalizing pot use for medical purposes. What this means for law enforcement is stepped-up efforts at arresting pot smokers. Recently, cops in California were given Q-tips and a black box, which in theory detect the presence of drugs in saliva. The problem with this technology is that only the mere presence of a substance in saliva is detected, not impairment. Positive blood, urine, or breath tests prove nothing but prior exposure. But of course, there's a lucrative contract to provide these tests to law enforcement. Number 2, DUI laws will change. When breath testing was developed, the AMA helped out and arrived at 0.15 as an alcohol level of presumed impairment. That level was changed to 0.10, then to 0.08, making the alcohol level alone the offense, not actual impairment. Let's fast forward many decades to 2013, when NHTSA, the National Highway Traffic and Safety Administration, floated the idea that all states lower their alcohol level for presumed impairment to 0.05. There's even 0.02 laws, 0.01 laws for under 21 age drivers, creating zero tolerance. What we've seen is a shift from focusing on actual impairment by alcohol to making arrests and convictions easier by creating artificial breath alcohol levels and even mere presence of alcohol. Notice the stress on convictions, not actual impairment. Could we see zero tolerance laws down the road for adult DUI cases? Could we see attempted drunk driving or aiding and abetting drunk driving? Number 3, new ways to collect evidence. Back in the day, police officers gave their opinion of impairment based on the driving pattern of a car, physical signs of impairment, and sobriety exercises. Then we moved to better breathalyzers and blood tests. Portable and handheld breath testing devices are used at the scene for probable cause to arrest. Then another test on more reliable breathalyzer is used at the station, which continues to be used as evidence in court. Enter technology and saving money. Expensive breath testing machines will be replaced with simpler and cheaper handheld units at the scene of an arrest. Blood samples will be obtained by warrants signed by judges at DUI roadblocks. Number 4, constitutional rights will erode Supreme Court decisions over the years. Those rights have been eroded in DUI cases, what a colleague has referred to as the DUI exception. We've seen validation of DUI roadblocks and double jeopardy, administrative license suspensions at roadside, criminal prosecution for the same conduct, no right to a lawyer before deciding to take a breath test, and presumed admissibility of a breath test result if the test is taken within 3 hours of driving. The trend is away from constitutional protections of citizens to protecting the police and prosecutors from pesky legal challenges. Number 5, making DUI a federal issue. Prosecuting DUIs is left to the individual states, but with groups like MAD bringing political pressure to bear and politicians looking for an issue that voters will like, there are changes on the horizon. The federal government has pressured states to change their laws or suffer not getting boatloads of federal money for highway improvements and law enforcement grants. What have the states done? They've created laws presuming impairment at 0.08, zero tolerance for drivers under 21, automatic license suspensions, standardized field sobriety tests, and federally approved list of breath testing machines. Number 6, the new prohibition. Breath alcohol levels for DUI have dropped from 0.15 to 0.08, and there are efforts to reduce it to 0.05. Drivers under 21 already face 0.01 in some states. MAD has formally changed its mission statement from drunk driving to include the problem of underage drinking, not underage drinking and driving. MAD's slogan moved from "Don't drive drunk" to "Don't drink and drive." They're focusing on the problem of drinking in any quantity at all. MAD wants mandatory ignition interlock devices installed on every car for every driver convicted of DUI, even first-time offenders. And even in cases where alcohol wasn't a factor, like DUI by drugs. It just makes no sense. They've been able to accomplish this in over 20 states at current count. And if they had their way, all cars would have ignition interlock devices installed. Number 7, expanded DUI diversion programs. Brought on by the financial pressure of paying overtime for cops who make DUI arrests and prosecutors losing cases in court, some counties have rolled out diversion programs for first-time DUI offenders. In many programs, completion of the program will result in either a dismissal of the case or a reduction of the charge to reckless driving. MAD has a voice in these programs, as you would expect, getting their piece of the financial pie in the form of a hefty charitable contribution. Visit my website, DUILawDefense.com, for more information about this and other DUI-related topics. I'm Attorney Jonathan Blecher.